Fund is available, State Victim Compensation Fund is available, and then BNSS mandates victim-centric trials allow compensation claims. Compensation in one of the judgment, Bijoy versus West Bengal court, the court has also emphasized to give more compensation other than the regular required compensation, since the state has the responsibility to protect the children and failed in its activity. So in-camera trials, most specified, mandatory in-camera trials are there. Mandatory in-camera trials to be conducted, which is already in place. So especially establishment of our court in Hyderabad city is one of the greatest court for the child specific this thing. Then speedy trials, Juvenile Justice Board to conduct a trial in 4 months, but child friendly and fast track courts, as per the the POCSO Act, the judgment shall be completed after taking the cognizance in 1 year. So time bound investigation for the police officer in 60 days, and this is also being seriously monitored by all the child sexual abuse cases and also rape cases by the Government of India Ministry of Home Affairs. So non-disclosure is one of the important provisions available under the Juvenile Justice as per 74 and also section 23 of the POCSO Act. Then disclosure also is an offence under BNS 72. Presumption clause is there. This section presumption clause, that is age, has been much talked on this by Sir Bhupati sir. There is abatement clause under POCSO. Whoever abates, then the punishment is there under 17. The presumption is very, very important clause. This the accused has to prove his guilt. Then public awareness is one of the important arena in which all stakeholders have the responsibility to conduct public awareness about the POCSO Act and JJ Act and the offences committed. In this aspect, the Bharosa centers are doing a lot of work by analyzing the hotspot analysis and then conducting awareness campaigns. This is some just words that we have to conduct copies to the victims. No face-to-face meeting of the child accused, and no to keep the children in the police station beyond sunrise and sunset. No publishing of material. Safe corners. In recent times, we have opened many safe corners in the police stations for dealing with the POCSO as well as the juvenile cases. There is beautiful institutional mechanism was established to provisions have been provided in Telangana. One is that Bharosa, you all know that Bharosa officers are also is there. A single window system, support for handling towards quest for justice delivery and rehabilitation. It's a 24 hours running organization, and video conferencing facility is also there. In some of the cases, honorable magistrates have conducted video conferences. Recording 161 statements is by the police officer. In all Bharosa Center, one sub-inspector of police has been provided. One of its kind child-friendly court was established in Hyderabad city. It's a paperless center administered by the Bharosa Society, headed by the Women Safety Wing Additional DGP Madam. And child rape and child sexual abuse cases have been taken. Initially, it was opened in 2006 with one center, but in 2021, it was started in a massive way. By now, we have created about 29 centers across the Telangana state, each district having one Bharosa center, and in tri-commissioners, we are going to have 2-3 centers in each district. Thereby, we are going up to 35 centers. Immediately, as soon as the victim comes to the police station, she will be immediately sent with a requisition to the Bharosa Society, where the Bharosa people will go, and then victim will be examined by the psychological person, who is psychologist already recruited there, and she will examine the victim, and thereafter, after talking to her, after conducting an interview, then she will put to before the police officer for recording the statement under 24 of the POCSO Act. And then medical examination also conducted in Hyderabad city. We have the facility. In some other district center we do not have, and that if that facility has been provided, the long waiting of the victim at the hospital will be avoided. Then we have the legal facilities. The legal support person is provided for handling the victim and their legal rights, and also accompanying the victim for recording 164 statement at the court, magistrate court. Rehabilitation rehabilitation has been provided. Shelter is being provided by producing before the CWC. We will outreach to generate awareness, And the beauty of the Bharosa Society and Bharosa Center is we have provided the victim compensation fund about ₹1,00,000 in the each Bharosa Center to meet the immediate medical expenses of the victims of the sexual abuse. And this is a feather in our cap that the Honorable Supreme Court in Nipun Saxena versus Union of India has categorically stated to provide one-stop centers, and one such center which is already been set up is Hyderabad Bharosa. This can be used as a model for another one-stop centers in the country. So we have also provided the institutional mechanism provisions is child-friendly corners have been created. 10 centers have been created in Sangareddy and already in operational. With the help of UNICEF, we have taken the assistance from the UNICEF also in providing these centers, where the victims of juvenile children or child in conflict with will be provided, and also we are using these centers for the victims of sexual abuse. Infrastructure in place. These are the places we have already created. This is a reserve open. This is the creation of our juvenile justice, special juvenile police units. Pre-protection rules also we are following for the children under Rule 16 of the JJ Act. No FIR shall be registered like that. And forwarded the nature, the probation officer facilities are being used in the cases. And these are all the prohibited. Production of the child is to be in conflict with the law before the board. No handcuff for the children and not used or coercive forces. Inform the charge made against the children through the parents and guardians. Not to compel the child to confess his guilt. Like parents, guardian may be present during the interview of the children. No feeling of custodial interrogation. Not to ask the child to sign. CWP shall be in plain clothes, which we are ensuring. And general principles is one of the important area we are focusing. The diversional alternative principle we are implementing in Hyderabad through she teams, where the victims of children in conflict with law who are caught by the she teams are being diverted at the police station itself by taking an undertaking from them and conducting counseling. Then principal assessment is one of the important area where principal magistrate will conduct the juvenile justice board conduct for the conducting trial of the accused of 16 and 18 years age. This is wage verification, sir, as Ali categorically treated. Sir, here we are facing and we need your intervention here. The most of the police cases, when we see the FIRs, only the bona fide certificate are being submitted with the charge sheet. Bona fide certificate is not a valid certificate. So I think we need some good insight on this, because many of the problem we are being facing on ground is that many of the victims are illiterate. They do not have the birth certificate.
For that also there is an answer by the Supreme Court.
Yes.
TC is also not accepted.
That TC is also not accepted. Study certificate is also not accepted. Only the matriculation certificate accepted. Board certificate.
Only those mentioned.
Matriculation and board certificates, sir, and also municipality and corporation and panchayats. The problem we are being facing is that the children are illiterate. They do not have the date of birth. Only we have the evidence is that Aadhaar card, which is not admissible. And the last availability is that bone ossification test. In many of the cases, it is going in favor of the accused, because the doctor is giving the his opinion between 17 to 18 years, and sometimes or 16 to 18 years, and in sometimes it is 16 to like that. So that is also the problem. And also here in bone ossification test, since we have to expose the children for the radiation, this thing, that is also posing danger to their
so also driving license,
yes,
and Aadhaar card also not accepted.
Not accepted, yes, that's what, sir. So this is actually for the consumption of our police officer. I have specifically made this slide. Then in this recent Honorable Supreme Court judgment again reiterated that in the form of school register was not sufficient to arrive at the conclusion that the POCSO were less than 16 years. So invariably we need to have a date of birth certificate and SSC certificates. Otherwise, we have the only method is bone ossification test. So in this thing also, we have a lot of stakeholders are important in this convergence for converging all the laws. So these are the police are to record the statements under 24 of the POCSO Act. in plain clothes, the police officer, and language to be used, the same language spoken by the children, the medical examination to be conducted, the frequent breaks to be given to the child. So police officers should read out loudly to the victim and then record. The child dignity have to be protected like that. And then magistrate has to record the statement within 24 hours as emphasized in the Tarkar Sivana versus Karnataka state, which is not happening, sir. The statement have to be, this is one of important ideas which I wanted to emphasize. Then medical examination is another problem. This is also not happening in 24 hours. The victims are being, in queue. So the medical, actual law, it is called as a medico-legal emergency as per the POCSO 27 Act and also in the 164 of 184 of BNSS. So compensation. These now we have trained all the SHOs in the state, sir, through our honorable DGP, sir. We have providing now the Form A format under POCSO rules to the victims, giving entitlement of this thing, and also preliminary assessment to report. So this is the Child Welfare Committee. In three circumstances we are producing the victim before the Child Welfare Committee, when the accused and the victim are in the same household, because we have the most of the cases pertinent to this case, so 94% cases are on this nature. Child is living in child care institution and when the child is without any care. So support services we are providing, appointment of support person is there. Then child friendly procedures of all judges, they know this. This is an important aspect, sir. We all converged today to make the child an important aspect, make the child to be free and make the child to not to re-traumatize, all the stakeholders to converge, and their important judgments which are there. And finally, I request, let us protect the child rights and the best interest of the child. Thank you so much, one and all.
Thank you, sir.
Thank you very much, Sri Ashok. And I will not say anything because we are already 25 minutes behind our schedule. And just 1 minute. And we have another session. Justice Vijay Sen is waiting for his session. So I will not take my 10 minutes. Just wanted to thank my panelists for raising very important issues. To Mr. Bhupati for showing us the decisions, citations, to Ms. Rajeshwari, educating us about so many different concepts, cyber crimes, child sexual abuse material. Interesting that from child pornography now we use that expression, child sexual abuse material, and because it shows that there's a shift somewhere in our thinking, that pornography, child pornography is not for our entertainment, but if we actually indulge in it, then we are liable for an offense. And to Sri Ashok for giving us a total overview of what the laws are and where to go in case you have a problem. So thank you very much, and but most of all to all of you, all my colleagues, my esteemed colleagues, my friends, Ms. Ramachandran, everyone, Mr. George, everyone in the audience I know. Thank you very much for being with us, and all the best for the next session. I'm sure that will be an equally great success. Thank you.
Thank you, Milad, and other honorable resource persons on the dais for such inspiring and thought-provoking deliberations by focusing on important provisions relating to child in POCSO Act cases, along with other laws. We would like to take this opportunity to express our gratitude to Her Lordship and other honored resource persons for their generosity and kindness in gracing this occasion by felicitating them. For this,
sir, just 1 minute, sir. Just 1 minute. With the kind permission, Chair, I want to tell one important judgment, because what is happening is the Supreme Court frowned the practice of using the word child pornography in judgments, but still judges are using the word child pornography. Recent judgment, that we should keep it in mind. They frowned it. Recent judgment, Just Rights for Children, Aliens and Others versus S. Harish and others. 2024 SEC Online, Supreme Court page 2611 is its citation. Please note down. Supreme Court frowned it. They asked the courts to use the word CSEAM, C-S-E-A-M, CSEAM, child sexual exploitation and abuse of material. They gave such direction to the Union government also. Press is correctly using. Recently I read some articles in Hindu and Times of India. They used the word CSEAM. They did not use the word child pornography. But we are using. Please see judgment, paragraph 260, Roman 1, Roman 2. Please kindly see. Paragraph 260, Roman 1, Roman 2. There is a wonderful judgment of Justice J.B. Pardiwala and Justice Chief Justice D.Y. Chandrachud. Wonderful judgment. They frown the practice. The government may not follow, but we have to follow. Please kindly note this.
Thank you, sir.
Thank you.
Sir, now I humbly request Honorable Srimati Justice E. Tirumala Devi, Madam, Judge High Court for the State of Telangana, to kindly present a memento to her Lordship. Honorable Ms. Justice Maushami Bhattacharya, Judge High Court for the State of Telangana and Chairperson of the Committee to monitor the cases filed under POCSO Act. Now I humbly request Honorable Sri M.B. Ramesh Sir, Principal District Session Judge, Asifabad, to kindly present a memento to Honorable Sri C.H.K. Bhupati, Principal District Session Judge, retired. Thank you, sir. Now I humbly request Dr. Chetana, IPS, Women Safety Wing, to kindly present a memento to Ms. Rema Rajeshwari, IPS, Deputy Inspector General of Police, Women Safety Wing, Telangana. Now I humbly request Sri Akeshwar Rao, Joint Director, Women Development and Child Welfare, to kindly present a memento to Sri Pagadal Ashok, Additional Deputy Commissioner of Police, North Zone, Hyderabad. Now I seek the permission of the Honorable Chair to declare the session closed. Now it is time for tea break, and all are requested to reassemble for the next session at within 10 minutes. In the lawn, tea is available, sir, for participants.
And why is convergence necessary? For the theme which we have today, the consultation, voice of the voiceless with special focus on a child. So when we think of convergence, we know that all these three acts, including I would say the Criminal Procedure Code, which has kind of joined hands on the statutory framework to protect the child and to keep a sustained focus on the child. Now, if we look at these acts, and apart from my colleagues, apart from my panelists, apart from all of you here, who have dealt with cases not only in the level of the courts, the district judiciary or the high courts, but on the ground level, as the arm of the law enforcement agencies, you will know that there are certain common objectives, common aims, which all these four statutes protect. For example, I can immediately think of about 5, 6 in-camera trials, identity protection, fast-track courts, immediate detection, no face-to-face confrontation, and of course, putting the child in a safe and a comfortable environment. So when I was looking at the three acts and I was thinking that what would be the points of commonality, what would be the points where the four acts come together, I broadly wanted to bring you about 4 heads. The first of which is victim compensation. The second would be fast-track courts. The third would be medical examination. The fourth would be early detection. There can be many other convergence points, but I thought that when the focus is the child, then these 4 would be extremely and immediately important to protect their privacy, to protect their rights. If you look at the object of the acts, of course you know that the Criminal Procedure Code, the BNSS, these are procedural laws. These will tell you where to go for redressal of your grievance, which is the court, and what would be the procedure after you go to the court. What would be the mechanism of the criminal justice taking over from the point of filing of the complaint. This is not a substantive law. BNSS, to an extent, of course, now it's a good mix of procedure and substance. But if you look at the JJ Act and the POCSO Act, you will find that what it needs to do, JJ Act, BNSS is sections 395, 396. Criminal Procedure Code, you will find section 357A, which talks of victim compensation. There are 2 important things to keep in mind. Number 1 is that the offender must pay, must compensate the aggrieved person, the person who has faced the offense, regardless of the offender's capability to pay. Very important. Number 2, the victim must be put to the position which the victim was before commission of the offense. So there cannot be, like we normally do in maintenance cases, so there cannot be a complete downgradation of the victim's position after compensation. So these 2 are important things to remember. And victim compensation, you will find that it has to be immediate, it has to be sustaining, and it has to bring the offender to book. I have about 10 minutes and I don't want to take up much time because I would like to hand over the talk to my much more experienced panelists. But if I go to the second, rehabilitation. What does rehabilitation do? You will find that the POCSO Act contemplates rehabilitation for child victims focusing on their immediate needs. So it's not that what the child will require 5 years hence or even 6 months hence, but what is the immediate need to rehabilitate? What are the social, the civil society forces to bring together to rehabilitate the child, to mainstream the child? You know that section 39, if I'm not mistaken, of the JJ Act that speaks of rehabilitation. That is all about not only mainstreaming but effective mainstreaming, so that the juvenile finds effective reconciliation with society. Next, I would talk about medical examination. Section 27 of the POCSO Act talks about medical re-examination and important things, medical examination, important things, that the consent of the child is very important. So if the child says, or if the child says that I don't want to be examined, then the next level is the parents. If the parents are not there, or if the parents are not available for whatever reason, then a medical board consisting of senior doctors, they can give an opinion whether the child should be examined, and if yes, how to conduct the procedure of examination. Next, if I talk about the JJ Act, it's not only about immediate examination, that is within 24 hours, but also the care and protection of the child becomes very important in that immediate medical care circumstance. Next is early detection and fast track. So under the CRPC and the BNSS, it starts with the FIR, which has to be promptly registered in with the police station, and the police officers will then be called upon to investigate cognizable offences under the order of a magistrate. And under 156(3), magistrates can also order investigation in certain circumstances, and including for unregistered crimes. Under the POCSO and the JJ Act, the incident must be reported immediately, so there cannot be any delay, just to protect the rights of the child. And the CRPC and the BNSS also provides for summary trials. I'll just quickly go to my next topic, which is the importance of age, which is the second subdivision of what we have to talk about. You know that under Section 29 of the POCSO Act, there is a presumption of guilt. And that presumption of guilt is entirely dependent on whether the victim is below 18 years of age. I think Section 2D of the POCSO Act defines child, and I think it's Section 221 or something of the JJ Act which defines a child. Everything, about below 18 years of age. So presumption of guilt actually under Section 29 requires the court to treat as the first foundational fact as to whether the victim was below 18 years or not. Because if the victim is above 18 years, then of course the entire mechanism of the criminal procedure trial, that changes, and there is no presumption of guilt under Section 29. But if the victim is of course below 18, then the entire presumption of guilt arises under Section 29. And then if you see from the POCSO, if you shift your gaze to JJ Act, you'll find that Section 15 of the JJ Act talks about presumption. It can be through visual appearance, it can be through interactions with the offender, with the or the child or the person who has suffered the offence with the JJ board. But it is actually Section 94 of the JJ Act which lists these three, I think Section 94 1 or 2, but it has these three ways of determining age. Number 1 is school certificates. Number 2 is certificates from the corporation, municipal corporation. And number 3 is the ossification test. And when I was doing a little bit of reading actually last night, I came across these this one technique which is being used now by the US immigration authorities. You know that there is huge thing going on under the president of the United States policies that immigrants should be sent back, etc. They've come across this test called the wisdom teeth test, and that wisdom teeth test is the third molar tooth which usually sprouts between 17 and 25 years of age. And they feel that the margin of error in the wisdom teeth test is much lower than the bone ossification test. The second, the recent technique which I came across is called the epigenetic clock. The epigenetic clock test. That actually measures the age using the age of DNA and the age of, the methyl conditions of DNA, that how old is the particular tissue in the body of the victim. So can you imagine how advanced and how scientific these tests have become just in order to determine age. And under the POCSO, you know that it is so important to determine the age of the victim so as to not only sometimes protect the rights of the accused, but also to bring the accused under the book because of Section 29, the presumption of innocence. And in a 2022 judgment of, I think, authored by Justice Pardiwala, it's called Shubham Sankra 2022. I've forgotten the citation. There, the Supreme Court also took into account the ways of measuring of age determination under Section 94 of the JJ Act, read with Section 15 in some circumstances, and saying that, visual appearance of a child or visual appearance, how a person looks, cannot be a determinative factor, and it can be full of error, and therefore specialized tests must be developed to determine age. And the last, of course, I'll just one line on that, is the cyber crimes. You know that now children are, the biggest victims of cyber crimes, whether it's child pornography, whether it's, morphing the image and, using that particular child's face. And it is so quick, it is so heartless, and it does complete and lifelong damage to the child. So I'll forget to just quickly in 1 minute show the slide, so that since I've spent some time on it, so might as well show it. So just the convergence, I've already spoken about these things. That's the JJ Act, the POCSO Act, and the BNSS, and the difference as well as the convergence in these three acts. Then the definition of a child and victim under the legislations. You have the sections under the JJ Act, POCSO, and the BNSS. And I'm quickly going through it, but it's with Mr. Panchakshri, so he can share it with anyone who's interested. It's just 8 slides. Then we have the victim-centric approach in the law, and again under that you have the JJ Act, POCSO, and BNSS, and how is the victim treated under these 3 acts. So I've just tried to also include children with disabilities, which is very important now, because that they should receive special care under every circumstance, and accessible procedures which are available to children with disabilities, and that is covered under the POCSO as well as the BNSS. And then of course you have the victim compensation under the law. I've discussed about it, the BNSS, the POCSO, and the JJ Act. The sections, I've just mentioned the sections. For all those of you who are not lawyers, but it's not important to remember the sections, just how the Act deals with these issues. Then, of course, the importance of age of child. I've spoken about this, that why is age so relevant and should be the focal point in POCSO cases. And medical examination. Under Section 27 of the POCSO Act, what are the rights of the victim? What is the procedure to be employed for the medical examination of a child? And role of special courts in POCSO cases, very important. Many of you here have handled these cases, many of my colleagues have. So Section 828 of the POCSO, what does it envisage? I'm just quickly going through. You can have a look at it later. And visual assessment, never enough. It cannot be a complete determination. And reasonable doubt about age of the child, Section 94, it's 94.2. 94(2), 2 and 3. What does it mean? If there's a doubt, what can the court do? Are there processes for the court to employ if there is a doubt? And yes, about the wisdom teeth technique and the epigenetic clock, which I just spoke about. And that's, yes, that's State of Jammu and Kashmir versus Shubham Sangra, 2022. That's the Supreme Court decision, Justice Pardiwala sitting with Justice Rastogi. Yes, so that's about it. Thank you, and I'll very happily give the mic to my my specialist panelists who will be giving you the ground level experiences of what they have come across. Thank you.
Dignitaries on the dais, Justice Mosumi Bhattacharya, Srimati Rema Rajeshwara Garu, Sri Pagadala Ashok Garu, dignitaries of the dais, the Honorable Judges of the High Court, District Judges, and judges of all cadres, and police officers of different cadres, the stakeholders of POCSO, my pronouns to one and all. The topic assigned to me for this technical session is age in POCSO cases, the complexities in determination of POCSO cases. Really, at one time, it was very challenging. Of course, still also it's very challenging. It's not only interesting, but also challenging. It was more challenging, and it was an emerging issue while we were the initial judges of POCSO courts. Those were the days when we were the initial judges of POCSO courts after the advent of the Act 2012. But now, there is no res integra. Everything is tailor-made, thanks to the judgments of the Supreme Court from time to time and various high courts. So within the time constraints, I would like to deal with some of the judgments of the Supreme Court and various high courts to make the point so simple. There is nothing to be worried. I make it clear, nothing to be worried, and this controversy is set to rest. See friends, age of a child. So we have to see from two different angles. First is age of a child as a victim. Age of a child as a victim. And the second thing is age of a person on the other side, whom you call it as a juvenile within the meaning of the word juvenile under Juvenile Justice Act 2019. And also the other category of a juvenile or CCL who can be treated as an adult for the purpose of trial by Children's Court after the opinion expressed by Juvenile Justice Board within the meaning of section 14(3) read with 15 read with 18(3) of Juvenile Justice Act. So these things you have to pay concentration. The first thing is
ensuring these cases more quickly through court sends a strong message of seriousness. The goal is trials to be completed in months, not years, so that victims and their families feel that justice is being taken seriously. Victim and witness protection measures. Victims of child abuse and their families are inherently vulnerable socially and emotionally. POCSO's provisions aim to protect them in addition to anonymity under Section 23 and in-camera trial under Section 37. The Act and related guidelines provide special accommodations. For example, witness can testify via CCTV and behind screens, and court may allow support persons or experts to accompany the child. The National Commission for Protection of Child Rights and State Commission have issued detailed rules for supporting child complainants and witnesses under Section 39. Unfortunately, implementation gaps remain. A recent judiciary report found that over 80% of the districts lack vulnerable witness deposition centers or separate child-friendly rooms. This underscores the need for improved court infrastructure like waiting halls, playrooms, ramp access, trained staff to reduce further trauma. Now, what is the role of civil society, legal aid and statutory institutions in child protection? Beyond the statutory provisions and judicial mandates, civil society organizations and legal aid institutions play an indispensable role in effective implementation of protection of children from sexual offences. These organizations act as bridge between law and the victim, ensuring that child's journey through the criminal justice system is not re-traumatizing. Numerous NGOs work in coordination with police departments, prosecution units and judiciary to sensitize key stakeholders. They conduct training programs for police officers, especially those in juvenile and women protection cells, focusing on child-friendly procedures, gender sensitivity and trauma-informed approaches. Many NGOs also accompany victims and their families to court, ensuring their rights are protected and they are supported with counseling, legal advice and shelter when required. Role of national and state commissions and the oversight. The National Commission for Protection of Child Rights, for short NCPCR, and its counterparts in state commissions are pivotal statutory bodies constituted under the Commission of Protection of Child Rights Act 2005. Their primary mandate is to ensure that all laws, policies and programs are in consonance with child rights framework outlined in Constitution and international conventions like United Nations Convention on Rights of Child. These commissions have given statutory authority to inspect childcare institutions, juvenile homes, special courts, monitor the implementation of POCSO proceedings, investigate complaints of delay or insensitivity, recommend policy changes to the government and ministries, conduct awareness drives and legal literacy programs among children, parents and communities. In particular, commissions can appoint child welfare experts or assign support persons under Section 39 of the POCSO Act, whose role is to guide and assist child victims throughout the legal process. This plays a crucial role in restoring the child's psychological and emotional confidence. Alongside child commissions, the National Commission for Women and State Women Commissions have overlapping mandates when it comes to protection of child, especially in cases involving trafficking, abuse within families or sexual exploitation in institutions. These commissions also offer legal assistance, counseling services, shelter homes and help in rehabilitation of the victims. Legal aid and access to justice. Under Legal Service Authorities Act 1987, every district legal service authority, DLSA and state SLSA is mandated to provide free legal aid to children, particularly those from economically or socially disadvantaged backgrounds. POCSO victims are entitled to legal counsel at state expense from the stage of recording FIR through to trial and appeal. The Legal Service Authority, in collaboration with bar associations and NGOs, often conduct sensitization program and outreach programs to spread awareness about their entitlements. Supporting legislations, strengthening the ecosystem. The Juvenile Justice Act 2015 complements the POCSO framework by ensuring that even a child in conflict with law are treated with compassion and reformative principles. The Act prohibits capital punishment and life imprisonment without possibility of release for child offenders. Now, since I'm short of time, I'll just refer to the other statutes where protection is given to the children, that is Right of Children to Free and Compulsory Education Act 2019. Then other schemes of central government like Ministry of Women and Child Development, wherein they have schemes like Child Protection Services Scheme, One Stop Center Scheme, Ujjwala Scheme, Nirbhaya Fund, etc. Now, in conclusion, let me say the promise of POCSO Act is upheld not by law alone, but by interconnected web of statutory institutions, commissions, civil society and legal aid mechanisms that give meaning to its provision on the ground. The combined efforts of judiciary, executive and social sector ensure that no child walks alone in their fight for justice. Protecting children from sexual offences is a collective obligation, legal, moral and social. International norms, UNCRC, ILO, etc. set broad objectives. India's POCSO Act translates them into concrete law with stringent penalties and child-friendly processes. Yet statutes alone are not enough. The judicial activism mandating special courts, fast trials, infrastructure improvement must be matched by diligent state implementation and community vigilance. Investigators, prosecutors and judges must receive training and adequate resources so that no POCSO case drags on unreasonably. Equally, society must listen to children's voices, never ignore a report of abuse and support victims without stigma. By enacting POCSO and related laws, India acknowledges that child protection is everyone's responsibility. Now it is imperative that courts, government, police, educators, families and citizens work together in policy and practice to fulfill that responsibility. In doing so, we not only uphold the rule of law, but also safeguard the most vulnerable amongst us, ensuring a safer future for every child. Thank you for giving me this opportunity. Now, many of you sitting here, particularly judicial officers, might be knowing about our co-panelist, Mr. Revanth Reddy is one of the senior most judicial officers, and I request him to commence his session.
My Lord, Honorable Sri Justice B. Vijay Sen Reddy Garu, my co-panelist Sri Soni Koti Charge Garu, Honorable Judges of the High Court for State of Telangana, all the dignitaries assembled here, a very good afternoon. My topic should have followed Mr. George because the topics overlap. Since George will be speaking of the legislations, I will be speaking of the obligations the legislations impose on the state. But be that as it may, I will do my topic. Any gaps are there, Mr. George's speech will cover them. And I am not going to speak of the various legislations in detail. Sir, I will just tell you, I am sure this side of the audience would have heard of this. I am sure those of you who have studied law on that side would also have heard of this. HLA Hart said, oceans of ink were spilled to define what law is. Now today we are gathered here to deal with child rights. I would say similarly, as vast oceans of ink were spilled to define what a right is. Now the reason why I speak of this is rights are defined variously, they have various meanings. So for our purpose, I adopt one particular definition. That is, you have a right if you can find an authority to enforce it. Telugu, I'm sure all of you understand Telugu, right? I have a right not to be beaten. Unless my friends in khaki are standing before me, I don't have that right. I have a right to realize some money. Unless my brothers and sisters sitting here give me a degree, I don't have a right to realize it. So, as long as we have an authority that says, I will enforce your right, I will protect your right, we have a right. Otherwise, it's just paper. That is what the role of government is. I'll give you a just brief, very vague outline of how these rights came about. In olden times, in pre-modern times, there is even a debate now whether a concept called a child or childhood existed. today we have defined terms. We say child is less than, any person who is less than 18 years. His life, we define his experience as childhood. We define a particular age group as adolescence. There is a very big debate whether such a concept existed a couple of 100 years ago. Consequently, children used to do whatever adults used to do. They would work in the farms. If the father is a blacksmith, they would work in the smithy. If he is a tailor, he would work in the tailor. He was a weaver, they would assist in the weaving. So there was no distinction between what work an adult would do and a child would do. But as time progressed, as more education started spreading, and as industrial revolution came, this distinction, the lack of distinction, what happened was, children were also employed in the factories, and you know how factories are. In the mines, they suffered hell. The best example is Oliver Twist. If you read it, it's set up in Victorian England. It shows the fate of children at that point of time. There is another thing, there's something really called phosphorus girls, matchstick girls rather. These were girls who suffered deformity because they handled phosphorus for making matchsticks in factories. Seeing this in Victorian England, they enacted the Factories Act, regulating the age at which children can be employed. As times progressed, as conception of rights, as conception that human beings inherently have rights have come, so also various groups of our society, women, colonized peoples, children, their rights have been recognized. So we had in 1925 the Geneva Convention of Declaration of Rights. In 48 again United Nations declared the rights and again adopted it as the Child Rights Convention. This is the vague history of it. But then if you read the Child Rights Convention, Mr. George will deal with it. Every article says the state parties shall do this, state parties shall do this. Who are the state parties? All of us sitting here are the state parties. See, we are representatives of the state. We are the hands of the state. For the Child Rights Convention to operate in Telangana, we are the persons who have to do it. What the Union of India, that is Indian government and the state governments do to perform or to comply with the obligations under the conventions is they would enact the legislations. The Juvenile Justice Act, the Child Rights Protection Commissions Act, Child Marriage Prohibition Act, amendments to the Factories Act, POCSO Act, all these things come. But then, without the state machinery, they are just words, they are just letters. They have nothing to do. So what is the role of state? State controls the purse and the sword. So state has to invest it in creating the infrastructure. It has to use its sword to enforce them. Then children have rights. So sir, now I am sure we are all working in the system. We know how the system works. Since I have worked on the judicial side, I know what infrastructure defects we have on the judicial side. Juvenile courts are manned by magistrates who are not regular, they are rather regular charge of that court. They attend to it at the maximum 2 days in a week. There are requirements of the juvenile court that every child has to be, they have to be, they should, a clinical psychologist should attend to them, especially where the heinous case offences are alleged against them. I ask my colleagues, they say, sir, there is no clinical psychologist. We don't have a clinical psychologist to whom I can send the child for analysis, for a examination. When I was in Sangareddy, I was told the observation home was closed and all children were shifted to Kachiguda, the observation home, and I'm not sure, near Kachiguda. Now, from Kachiguda to Sangareddy is about more than 100 kilometers, if I'm not wrong. So if a child has to be produced, they need an armed escort from Hyderabad city to Sangareddy. So children were not produced. POCSO courts. The first time I had experience with POCSO cases was when I was posted as Metropolitan Sessions Judge and First Additional District Judge of Visakhapatnam. We have a joke among ourselves, First Additional District Courts are like Swiss knives. The reason is, as Metropolitan Sessions Judge Visakhapatnam, I had 17 different designations. I was the special court for NDPS, POCSO, Electricity, Marine Act, PMLA, Human Rights Court, whatnot, 17 designations. And my pendency was about 2,300, out of which 1,125 were NDPS cases, 600 civil, 600 IPC, 74 POCSO, and about some miscellaneous cases of the rest of it. I had 625 under trial cases because, as you know, Visakhapatnam is the production center of ganja, and once a person gets caught in ganja case, he is not going to get a bail. So I had 625 under trials, every day 50 persons extension of remand, 25 to 30 bail applications, and at any given point of time 30 to 35 under trial cases. Now, what am I supposed to do with these POCSO cases? Right, I did try, because when I took it, I looked at the act and it says within 90 days, within 10 days or 30 days I have to record PW1's chief. So I said, okay, fine, let's do it. But among all that, that's the fate of all our courts. Now, when Act says you have to establish a special court, that requires a special court, it requires a special prosecutor. I didn't have a special prosecutor. I had one prosecutor who is a good man because he cooperated with me with the punishing trial schedules I fixed. But he was also the deputy director or joint director of Visakhapatnam. So he had his own administrative work. Still he worked. He cooperated. I was able to do it. Sir said defense counsels. When I fixed schedules, luckily in Visakhapatnam, the defense counsels did not take adjournment. They cooperated. On the day I fixed, trials were done. The reason it worked is people cooperated with me. The reason it worked is the infrastructure that I had was okay. I didn't have a special place to hide the accused, to all that, but we managed somehow. But then this will not work in the long term, and it hasn't worked. I am sure all of you are aware it has not worked. So the role of government and role of court is that we should make these things work. We should see that children get these rights. They will only get the rights when we enforce those rights, when we invest in the infrastructure for enforcing those rights. That is what the government should do. There should be a full-time magistrate for juvenile courts. There should be special courts. Now, I have one more difficulty with special courts. Visakhapatnam, as you all know, erstwhile is a huge district, and agencies and all that. When I was in Sangareddy, at that point of time, it was divided into 3 districts. Erstwhile Sangareddy, the Siddipet to Sangareddy is about 100 kilometers. So special court in Sangareddy for a victim in Siddipet is as good as going to the moon. Then we established fast track courts in the talukas, in the stations. That is a much better development. That's what is required. Special court by itself, it imposes an unreasonable burden on the police and prosecution because victims will be distributed across the district, but the court will be far away from them. That has to be answered. Even now, if you, I'm sure my friends on this side of the audience would identify atrocities against women courts. They are all in the headquarters. Victims, earlier, the nearest senior civil judge court was assistant sessions judge used to deal with them. Now, all the cases go to the headquarters in one court, and victims have to travel across the district to that court. So now, did it make things better or did it make things worse? And sometimes, because of shortage of judges, those courts were left vacant. So those are the things that are required, sir. The main things, like as I said, government creates all this infrastructure. It has to invest in it, invest in the policy. And one last thing is, we have to understand what children go through. As adults, we forget our childhoods. That also creates difficulty in designing policies and institutional mechanisms for dealing with children. That is also one role government has to fulfill. That is also one role all of us here have to do. So thank you, sir. Thank you for the opportunity.
I request Mr. Kuti George to start this session.
Honorable Justice Vijayasan Reddy Garu, Shashidhar Reddy Garu, thank you so much. I think good evening and a smile please. Come on, yeah. This is like very boring to be sitting like this. Can I play some cards? No problem. No, if I play, you will have gambling act also coming in. How many How many of you have seen playing cards? Everybody. How many cards are there in a pack? 52. Why you forget 2 of my photographs here? How many are there? 54. Okay? Just to tell you, yeah, 2 jokers are there. That's why I said 2 of my photographs. Yeah, 54. Actually, in UNCRC, UN Convention on the Rights of the Child, which defines what rights of children and what state obligations are, there are 54 articles. And there are these 2 jokers. What are the speciality of jokers? It goes with everybody. So the most important thing about the UNCRC is that you always are governed by 2 basic principles. The first basic principle is the best interest of the child. The best interest of the child. The second is the right to participation for the child. The CRC defines non-discrimination. I'll come to non-discrimination and others in 2 minutes. But this is the essence of universal declarations and CRCs and conventions, is to give a guideline. And most interestingly, I don't think I'll go into a PowerPoint presentation to make things complicated for you. Let's make it very simple. The most important thing in any action that we do, we are governed by certain basic principles. Basic principles. Now, defining those basic principles, from Beijing rules to Riyadh guidelines to all international conferences, meetings, have done all that. And do we have anywhere set of principles which needs to govern our action listed out? The guiding principles of our action? Any legislation? We've been talking legislations. Which ones? The JJ Act has a full chapter on the basic principles. And POCSO, let me tell you, on the object of the conference that is happening today, POCSO has nothing to do. Rehabilitation and reintegration of the child does not happen in POCSO courts. It does not happen in POCSO courts. the rehabilitation, reintegration is moved to the Child Welfare Committee, who has the responsibility to plan the rehabilitation program. Therefore, our discussions in any of the forums becomes meaningless because we go on looking at the act, the sector, what section, what, no. The basic principle comes from the best interest of the child. The presumption of innocence when it is a case of child. I wish you had that, just put that slide on the, just make sure that we understand that there needs to be guiding principles which will take us to where we are. And the fact that, go to the next. Go, oh. Okay, and it is very important that we realize that it is not going to be governed by the legislations, it is going to be governed by these principles which are listed here. And I will just go to the fact that after 1989 the CRC came. In 10 years' time we came with an optional protocol because we saw the CRC was not sufficient enough to deal with issues of sexual abuse. Then today we heard about the CSAM, the new word which is coming up. And it is an evolving, the most dynamic thing today is the internet space. And therefore the responses need to be there, so everything is happening. Last year and this year we have the Supreme Court and the NHRC giving guidelines on what to do with CSAM. We are working with the state to make sure that we have some state guidelines and action points. And therefore it is important that we realize what we do in terms of like what is it that we look at the basic principles, which I thought I'll just show you. Just here, the best interest of the child is defined by the views of the child. The best interest definition, how do we really make it happen? So you need to listen to the child. And within the legislations, we have a lot of spaces in terms of MTP, in terms of whether you want to medical examination. There are provisions which are based on the views of the child. There is the necessity to look at the child's identity. We are talking about tribal children. We are talking about children from all around. So we need to look at the culture, the identity of the child, vulnerabilities of the child, and preservation of the family. The family as the most important unit. But then even there, if the child wants to remain with the family or not, is something that the child will decide when there is a POCSO case. And that is where it is important for us to realize that the best interest of the child is the most important thing that we need to do. Look at the guiding principles. I am not talking from anything. This is under Section 3 of the JJ Act. It's a full chapter. And let me tell you, I was interviewing people for the JJBs and CWCs. Out of the 600 people we interviewed, not even 3 knew about the guiding principles. Now, all of us sitting here have been in this business for donkey's years. If we are not governed by these basic principles which are there, and if we don't start our judicial training programs, starting with these mandates which are there, which should guide every action we take. And therefore, it is necessary that we understand and move forward in this direction. I'm just not going into the details of what needs to be done and what is the objective of to these meetings. Why are we called us all together here? I'll just go to that and then finish. I'm just skipping all these. Yeah, just to look at these objectives. Why are we here? The business is to look at required policy reforms. Now, the policy reforms, I think I just loved what was said by you, because holding a mirror to yourself and being realistic about what is happening is the most important aspect of starting. If you don't say the truth, if you don't say what is the problem, we will never be able to solve it. And I think articulation and honesty is the first thing. And in terms of the policy, I think the best interest of the child, and how do we bring these focus onto the best interest? How do we bring the focus of our trainings into these aspects where these guiding principles are there which should guide us? Which is like, which is the most important thing. The object of the legislation, if this is the most beautiful thing about the act, is that Why we say POCSO and JJ needs to be read together? Because POCSO's role is limited. The rehabilitation role is under the JJ Act, and it needs to be governed here by these principles. And therefore, how do we bring that in our discussion? How do we bring those in our policies becomes critical. The second is interagency cooperation, collaboration. I think you heard what Barossa is doing. You heard what She Teams is doing. You heard what is happening in this state. Mushmi ma'am is here. She is doing this regular review, monthly reviews with these people, making sure things are moving. You have the commission, Children's Commission, who is mandated to be doing such functions everywhere. And interagency coordination does not happen sitting like this. This is upper-lower relationship. I am just talking to you. You are not challenging me. We need to have settings where we sit around, put the problems, hold the mirror to ourselves, say the problems up front. Then collaboration and working together becomes a reality. And that is the most important thing. And I think before we go into the last one, I have this to show. The whole dimension of human rights, child rights, start with the human dignity, dignity of the child. The dignity of the child in terms of when happens discrimination, abuse, exploitation, silences the child, de-dignifies the child. It does the maximum harm. Any sexual offense does the maximum harm, which takes ages for the child to come back. And there, for those voiceless, we are saying we need to rehabilitate, reintegrate, and give them, restore them back. And that restoration process is not an easy job. And POCSO courts do not do anything about it, because your role does not have anything to do with those. And that is done by CWC and others, who needs all support in making sure that the child from voicelessness comes back to a voice, gets back the voice, being natural, being able to survive, thrive, and go ahead in life. And I think it is not to learn from international experiences, it is in making sure that our good practices of Barossa, what we are doing, becomes a national, international good practice. The challenge before us is to bring people to take it to that level. And I take that challenge with you today to make sure that we are able to make a difference in the life of the children, and not just as POCSO court judges, not just as police officers, but we as a collective, staying together because the child needs it. The offenses, sexual offenses, does maximum damage to children. To revive them, it just does not work with one or two, but with all of us. And together, let us make this workshop a success and let every child enjoy their rights. Thank you so much.
Thank you, Mr. George. So we have heard Mr. Shashidhar Reddy, who has given good narration of child rights and historical exploitation of children in various forms, the obligation of all the stakeholders, and he has shared his personal experience and pointed out deficiencies in the system, like lack of clinical psychologists, overburdening of special courts dealing with POCSO cases, and practical difficulty he has faced when he was district judge of Vizag and Sangareddy. And Mr. Sonikuti George has enlightened all of us about the importance of JJ Act and rehabilitation. His PowerPoint presentation on best interest of child and necessity of all the judges to upgrade their knowledge in JJ Act, which are in tandem with the POCSO Act, I think should alert all the stakeholders, especially the judges who are residing the POCSO courts. And Mr. Kuti George's presentation on dignity of child, and also the importance of restoration and rehabilitation of the child. All needs to be paid attention at all levels. So to conclude this session, let me tell all of you present here, we are short of specialists and experts. All of us know. We have infrastructure, we have funds, we have policy makers, we have everything, but we are lacking specialists and experts. There are some things which I cannot elaborate, but when we are notifying posts for appointment of judges, you know, there are many applicants, but it has become very difficult for us to select them. Outside there is a criticism that there is lack of employment. But let it be an eye-opener for all of us. There are many sources of employment, but people got used to less work and more money. I don't know whether this is a problem in Telangana or everywhere in India. People want less work, a job without any expertise and regular salary. We need to change our attitude. We have to upgrade our skills at all levels. We need experts, we need judges. Now we do not have separate cadre for judges dealing with POCSO cases. Separate cadre is a very difficult task. However, in my personal view, there should be special courts and dedicated courts to deal with POCSO cases. For example, if there are 300 cases, the judge should deal only with the POCSO cases. Otherwise, you will not achieve the objects of this POCSO Act and GJ Act. And if the disposal rate is good and it is less than 100, depending upon the nature of work and the trial schedule, the judge can be assigned other works. But if the cases are more than 150, according to me, there should be special dedicated courts to deal with POCSO cases. And let me appreciate the Telangana police force who have received appreciation from all quarters, including the Honorable Supreme Court in operating these Bharosa centers. These Bharosa centers in Telangana have created a great space for women protection, and it is a matter of pride for all the Telangana people that Supreme Court has taken cognizance of this and said that this Telangana model should be followed in other states. So I congratulate all the police officers present here. So thank you very much for participating in this session, and even after lunch and tea break. Thank you.
Esteemed guests. Now, we would like to take this opportunity to express our gratitude to His Lordship and other honored resource persons for sparing their valuable time and kindness in gracing this occasion by felicitating them. For this, I humbly request Honorable Sri C.H. Ramesh Babu, Principal District and Session Judge, Jaishankar, Bhupalpalli District, to kindly present a memento to His Lordship, Honorable Sri Justice B. Revanth Reddy, Judge, High Court for the State of Telangana. I humbly request Honorable Srimati G. Neelima, Principal District and Session Judge, Medak District, to kindly present a memento to Honorable Sri S. Shashidhar Reddy, Chief Judge, City Civil Court, Hyderabad. I also humbly request Srimati Chandana, Member SCPCR, to kindly present a memento to Sri Sonikuti George, Child Protection Specialist, UNICEF. Now I seek the permission of the Honorable Chair to declare the session closed. Thank you. Thank you, Miller. And the session is continued. There is no tea break, please. Due to lack of time. I, on behalf of State Legal Services Authority, Hyderabad, Women Safety Wing, Telangana State Police, in collaboration with Women Development and Child Welfare, Telangana State Legal Services Authority, and UNICEF, welcome all the Honorable High Dignitaries, invited guests, participants present here, ladies and gentlemen, to this consultation meet for Technical Session 3 on providing free legal aid to the child victims under Legal Services Authority Act 1987, role of State Legal Services Authority in disbursing the compensation schemes of NALSA for the protection of children. It is now my honor to invite Honorable Sri Justice P.R. Madhusudan Rao, Judge, High Court for the State of Telangana, to kindly adorn the dais. Milord, please. Now I humbly request Honorable Sri G.V. Subramaniam Sir, District and Session Judge retired and former Member Secretary, Telangana State Legal Services Authority, Hyderabad, to kindly adorn the dais. To begin with, I humbly seek permission of Honorable Chair to declare the session as open. Milord, please. Thank you, Milord. The session is declared as open. Every great event begins with a heartfelt welcome. Milord. Milord, please. Sapling.
Sapling? You can give it afterwards.
Every great event begins with a heartfelt welcome. To do the honors, may I now request Srimati Lakshmi Sharada Madam, Principal District and Session Judge, Suryapet, to kindly present a sapling to Honorable Sri Justice B.R. Madhusudan Rao, Judge, High Court for the State of Telangana, Hyderabad. I also request Sri Honorable Sri Boya Srinivasul Sir, Principal District and Session Judge, to kindly present a sapling to Honorable Sri G.V. Subramaniam Sir. as our speakers make their way to the stage, I urge each one of you to open your mind to new ideas, engage actively, and soak in the valuable insights. I now request Honorable Chair to commence the session. Thank you, Mr.
A very good evening to one and all, and welcome to the state level stakeholders consultation meet 25 on voice for the voiceless, rights and protection of children of sexual abuse. I'll see that I may not receive any slip from the member secretary and I complete this thing within 10 minutes. The reasons for forming the Legal Service Authority is to implement Article 39A of the Constitution, which directs the state to provide free legal aid, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability, and to systemize the institutionalized legal aid services that were previously ad hoc or run by voluntary organizations. To make justice more accessible and reduce the burden of courts through alternative mechanisms like Lok Adalat, and to uphold the principles of justice for all, not just for the privileged. The Supreme Court of India, in a series of judgments in 1970 and 1980, like Hussaini Ara Khatun vs. State of Bihar, emphasized the importance of legal aid as part of fundamental rights under Article 21. Several critical debates took place between 1950 and 1980, both in legal circles and government policies forums. Legal aid, a right or a charity? One major debate was whether legal aid should be considered a fundamental right or a welfare service. Progressive judges like Justice P.N. Bhagwati argued that legal aid is part of the fundamental rights of equality under Article 14 and Article 21. And others feared that such a right would place unsustainable financial demands on the state. Should legal aid be administered by the judiciary or to maintain neutrality or by the executive for efficiency? The final decision favored judicial leadership to preserve impartiality and public confidence. Why legal aid? There were disagreements over how to define the weaker sections of the society. Some favored broad inclusions, and others argued for a more restricted income-based approach. And the federal neutrals of India led by discussions about how much control the central government should have versus allowing the state authorities in implementing the legal aid programs. The formation of Legal Service Authority system took place in phases involving key reports, committees and legislative actions. Law Commission report, 14th Law Commission report of 1958 and under MC Settleward was the first to recommend systematic legal aid. Later, 42nd and 48th report further emphasized legal aid as essential to justice. Justice Krishna Iyer Committee 1973, this committee led by Justice V.R. Krishna Iyer emphasized that the poor must have the same access to courts as the rich, and the state must be responsible for ensuring it. The formation of CILAS 1980, that is the Committee for Implementing Legal Aid Schemes, was created under Justice P.N. Bhagwati. It proposed a nationally coordinated legal aid structure and played a vital role in spreading Lok Adalats and legal literacy. Legal Service Authority Act 1987, passed by the Parliament to give statutory background to legal aid schemes, and it created the National Legal Service Authority and its counterparts at the state and district level. The Act was implemented in 1995, delayed due to logical and financial concerns. Justice P.N. Bhagwati, often called the father of the legal aid movement in India. And what is the genesis of Legal Services Authority system? In 1958, 14th Law Commission report was given. The significance is that first official recommendation for legal aid. And in 1973, Justice Krishna Iyer Committee, legal aid as a constitutional responsibility. And 1976, 42nd Constitutional Amendment added Article 39A, free legal aid, made a directive principles. 1980, formation of CILAS, Justice Bhagwati coordinated national legal aid schemes. 1987, Legal Service Authority Act passed, provided statutory basics for legal aid institutions. And 1985, Act is enforced, NALSA is established, full implementation of structural legal aid system. Now, the session deals with providing free legal aid to the child victims under Legal Service Authority Act 1987, role of State Legal Service Authority in distributing the compensation, schemes of NALSA for the protection of children. I think this session will enlighten you about the Legal Service Authority Act, and I request Mr. Subramaniam to take over the session.
Honorable Sri Justice Masudan Rao Garu, the chairperson of the session, most respected judges of the Honorable High Court for the State of Telangana, sitting in the audience, Honorable Minister who has arrived just now and sitting in the audience, and respected police officers, respected judicial officers and other stakeholders. Because we are running short of time, I do not want it to come in the way, because I am told that the Muharram processions are going on, so you may have traffic problems, transportation problems. Therefore, I also, while sailing with your chair, would like to conclude the session at the earliest. But it becomes an imperative for me to deal the subject, at least cursorily. As we all know, Section 2Y of BNSS defines the victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person, and includes the guardian or legal heir of such victim. Why the definition of the victim has included the guardian is the aspect which requires an appreciation. We all know that particularly in sexual offences, when the victim suffers mental and physical trauma, there should be somebody in the family to attend to their needs. And obviously they have to have many sacrifices to meet their requirements and to bring them out of trauma and to have some reparation. I recollect one such incident where a 12-year girl was sexually molested, and her mother was an employee in central government. I may impress upon you that the child underwent such a traumatic situation that she was afraid to come out of the house. She was afraid to see any male person. Even she was afraid to look at her own father. Such was the situation.
In such situation, the mother was compelled to go on long leave for a period of 2 years and to take care of the child and see that she would come out of this traumatic condition. She was taken to psychiatrist, etc. So it is the guardian. The victim does not mean the one who has suffered the sexual assault directly, but it includes the guardian of the victim also. Therefore, with the wisdom of the lawmakers, with the wisdom of the Honorable Supreme Court, in view of the various decisions of the Honorable Supreme Court, the definition of victim has been expanded, and it includes the guardian and legal heir of such victim. I once again say that why the guardian has been included. Because our topic today is to deal with the compensation payable to the guardians or victims. Many a time the victims may not come forward to submit an application to either DLSA or SLSA. It is their guardians who will be coming forward to submit the application. Such applications have to be decided by the DLSA or MLSA respectively, considering various conditions, which I would narrate later. A sexual assault victim means a female who has suffered mental or physical injury or both as a result of sexual offense, including sections 74 to 79, 64 to 70 as per the new BNS. And who is the dependent? Because the subject is with regard to disbursal of the benefits of the scheme. It is necessary for me to define the dependent also. Who is dependent? Dependent includes husband, father, mother, grandparents, unmarried daughter, and minor children of the victim as determined by the State Legal Services Authority or District Legal Service Authority on the basis of the report of the Subdivisional Magistrate of the concerned area or SHO or investigating officer, or on the material placed on record by the dependents by way of affidavit or on its own inquiry. Here at this stage, in my little experience when I was working as Member Secretary of State Legal Services Authority, I have come across that whenever lump sum amount is to be paid to the victim or their dependents, as per the schemes promulgated or framed by NALSA or central government, the unfortunate situation I have seen is that several dependents were coming forward to claim the compensation, leaving apart the safety, security and other things which the victim desire. Then in such situation, SLSA or DLSA is depending on the inquiry to be caused by the investigating officer or the particular revenue authority, subdivisional magistrate. In my experience, I say there is inordinate delay in deciding as to who will be the dependent to receive the compensation. Unfortunately, in few cases, even Guardians and Wards Act OPs were filed to determine who will be the legal heir. Who will be the legal heir to receive the compensation on behalf of the victim. Such situation need to be answered by us, because the last clause of the dependent defines that it can be by way of an affidavit submitted by the dependents or on its own inquiry. So whenever such application is submitted, my appeal to all my stakeholders or all my members of DLSAs and the Honorable Member Secretary of SLSA is to determine the dependents as expeditiously as possible. Of course, the rules and schemes also contemplate that it should be decided within 60 days. So there is inordinate delay with regard to that. Then with regard to eligibility of compensation, a women victim or her dependent or dependents, as the case may be, shall be eligible for grant of compensation from multiple schemes applicable to her. While assessing the compensation awarded earlier under section 357 is supposed to be excluded. Recently, a scheme has been framed by the central government and NALSA also, which is called as Compensation Scheme for Women Victims and Survivors of Sexual Assault and Other Crimes. In the said scheme, fund does mean a victim compensation fund constituted under the state compensation scheme. Central fund means fund received from CVCF scheme 2015, and women victim compensation fund means a fund segregated for disbursement for women victim out of state victim compensation fund and central fund. We all know that probably many of the stakeholders would know that in the recent past the Telangana state government has enhanced the upper limit of the compensation to be payable to 10 lakh rupees for various offences which have been enunciated in the schedule. So, of course, for various offences, some particular slab has been fixed. I request the stakeholders to go through that schedule. And humbly request the Panchakshari Garu, the State Legal Services Authority, to circulate the GO that has been issued by the state government and other concerned material with regard to the payment of compensation. So, whenever a recommendation is made by a court for compensation, the DLSA or SLSA, as the case may be, shall decide the quantum of compensation to be awarded in the scheme referred earlier. And the procedure for submitting the application claiming the compensation is, it is mandatory to report FIR. Unless the FIR is issued, neither the victim nor the dependents will have any right to submit an application claiming the compensation. The SHO shall mandatorily share a soft copy or hard copy of the FIR immediately after registration with the SLSA or DLSA. The earlier speaker was saying, some George, that there are many latches where an FIR is registered either against the child or when there is a victim, that FIR is not being communicated to DLSA forthwith. So once again my appeal to my DLSA secretaries is to foresee that whenever the FIR is registered, it would reach to you at the earliest within 24 hours. An application for award of interim compensation or final compensation can be made by victim or her dependents or the SHO concerned. See the beauty of the act, that even the SHO also empowered to submit an application for seeking compensation, because some immediate needs have to be met. Immediate needs have to be met when a sexual assault is made against a minor child victim, because she needs some medical assistance, she has to be taken to the hospital, she requires some treatment, etc. Therefore, even the SHO is empowered to submit an application to the DLSA or SLSA, as the case may be, for seeking interim compensation also. There are provisions under all the schemes formulated by NLS and NALSA, that interim compensation also can be decided by DLSA. The place of filing the application for compensation is either DLSA or SLSA, and the secretary has to thoroughly go through the schemes announced by NALSA and the central government, and the DLSA secretary is supposed to decide the quantum of compensation to be paid. And there is a special provision for acid attack cases. when I was working in Madanapalle, long back. Of course, during those days, these good provisions were not available. A beautiful girl fell in love with somebody, and because he came to know that somebody is also loving her, one ill-fated day he has taken her to a park and he poured an acid on her face. The beautiful girl completely devastated, completely ruined. How much compensation would really compensate? I have taken cognizance under section 307, but initially it was 326A or something. I have taken under 307 and tried, and I gave conviction for 7 years, but the victim and her family members were not allowing me to go out of the chamber. They cornered my chamber, and they said that he should be hanged till that, or he should be imprisoned for life. The section doesn't warrant at that time. So as far as acid attacks are concerned, there is criminal injury compensation board. There is a criminal injury compensation board consisting of the principal district judge, SP, and the district magistrate, civil surgeon, and CMO of the district. So all these authorities can decide the compensation payable to them. I have already received a chit that I should complete. Cursor, if speedily, I'll just refer to the factors to be considered while deciding the compensation, okay? That have been mentioned in the, probably the material supplied to you, but to have an overview that, to know that. The gravity of the offence and severity of physical or mental harm or injury suffered by the child is the paramount consideration. The expenditure incurred are likely to be incurred for medical treatment. Then loss of educational opportunity, loss of employment as a result of offence, the relationship of the child with the offender, whether the abuse was a single isolated incident or took place over a period of time, whether the child became pregnant as a result of the offence, whether the